Hello, my name is Matthew Schiappa from the law firm of Lomurro Davison. I work in the Personal Injury and Workers' Compensation Department, and I'd like to take a little time and discuss with you when a motor vehicle accident may be compensable in the Workers' Compensation Court as opposed to the Superior Court of the State of New Jersey. Most of us still commute to work in our cars every day, and if you have a set office that you commute to, generally, if you're involved in a motor vehicle accident, it's not compensable in the Workers' Compensation Court. However, with most rules, there are always exceptions, such as if your employer that day told you to go meet a client at a different location, or if you're a traveling salesman or perhaps a tradesman that goes to various sites throughout the state of New Jersey, you would be considered at work as soon as you leave your home. Therefore, if you're involved in a motor vehicle accident at that time, you may have a claim that's compensable in the Workers' Compensation Court as well as the Superior Court of New Jersey. These are only a few of the examples of situations where a motor vehicle accident may be compensable in workers' compensation. It's very important that you consult with an attorney if you are involved in a motor vehicle accident. An attorney can help you out and determine whether or not your claim should be brought in the Workers' Compensation Court, the Superior Court of New Jersey, or both. An attorney will also be able to help you determine whether your employer's workers' compensation insurance should cover any medical needs you have, or if you should make a claim under your own personal injury protection coverage of your auto policy. Therefore, if you're involved in any motor vehicle accident, please give me a call, Matt Schiappa at Lomurro Davison. Thank you. Hello, my name is Matthew Schiappa, and I work at the law firm of Lomurro Davison in the Personal Injury and Workers' Compensation Department. I'd like to talk to you today about premise liability. You might ask, what is premise liability? Most people think of that as slip and falls or trip and falls, whether it's on a residential property, a commercial property, or perhaps property owned by a public entity, such as a town or county or state. The most important thing to know is that every landowner and or whoever is in control of the property has a duty to keep that property free and clear of hazards. However, just because a hazard may exist on a property and it may have caused you to fall and sustain injuries does not necessarily mean that that landowner or tenant or management company who has control over the property is liable for your damages. The most important thing you need to prove as a plaintiff against the owner, tenant, or management company who may have control of the property is that they had knowledge or should have known about the hazard and took no steps to remedy that hazard. So if you have fallen anywhere, be it a residential property, commercial property, or on a public property, you should consult with an attorney and they can go over the facts with you and determine whether or not you can impute such knowledge or prove such knowledge of landlord, tenant, or management company. Therefore, I urge you, if you have been involved in any slip and fall or trip and fall, that you contact me, Matthew Schiappa at Lomurro Davison, to discuss all issues. Thank you.